Well, first of all, let me say how delighted I am to be here. And it's the first time I've been to San Diego since I was 9 years old with my parents. But it's my first time in this august body, and it's a pleasure to be here. And it's a pleasure to have been asked to respond to such a thoughtful and wonderful paper. Yvonne's done a marvelous job of opening up a vista for us that I expect was previously unknown to most of you, certainly to me. What she didn't mention was that of the sources that she's used in this analysis, particularly with respect to the Malaysian courts, most of this material is not available in English, and she's translated it all herself. So in that way, I see her mission in comparative constitutional law much the same way that Wojciech Sadurski has brought materials from Eastern Europe, to an English-speaking audience. So a less Polish version of Wojciech bringing materials from Asia to us. Well, if she'd done nothing more than that, then that would be enough to earn our gratitude. But she's asked several probing and very difficult questions. I'm just going to focus on two of them in my comments. First of all is the question of why or even whether originalism thrives across diverse constitutional cultures. And secondly, the question of whether originalism is somehow, in some way, inherently a matter of judicial restraint, whether that restraint is understood in the sense of a deference to legislatures or in cabineting judicial discretion to expand individual rights. Is there something about originalism that is really deeply tied to judicial restraint? Well, let's look at, first of all, the question of the life of originalism outside of the United States. Now, I was completely unaware that originalist arguments are used in constitutional litigation in Malaysia, Singapore, Turkey, and elsewhere. And that really opens up the question of how many other jurisdictions are just out there hiding in plain sight. When doing comparative law, of course, much depends on where the mind wanders. And I think Yvonne demonstrates that for many North Americans, the mind doesn't tend to wander very far. But that said, I don't want to overstate things. Of jurisdictions that strike my mind as the closest comparators to the United States, say the European jurisdictions and those jurisdictions practicing what Stephen Gardbaum calls the new Commonwealth model of constitutionalism, originalism is still very, very much a fringe phenomenon. It would be an overstatement to say that originalism has no support or no scholarly support in those jurisdictions, but I'll note that of the Canadian constitutional scholars who take originalism seriously, approximately half of them are in this room at the moment. And I say approximately half only because Grant Huscroft is much larger than I am. Now, I can't fully account for the Canadian hostility to originalism, but it is in part a reaction to a label that's perceived to be American and conservative and possibly vulgar. And a few years ago, when Huscroft and I invited, well, some of you, up to Western Ontario to engage with Canadian scholars on the subject of originalism, and specifically with Canadian living tree folk, the Canadians didn't see it as a good way to spend a weekend. And in fact, none of them came. Now, to be fair, I should mention that there's now a small but able band of neo-Costanzian originalists in Canada, named, of course, after George Costanza. You remember George's conversation with his therapist, that God would never let me be successful. He'd kill me first. He'd never let me be happy. The therapist says, I thought you didn't believe in God. Well, I do for the bad stuff. The neo-Costanzians believe in originalism, but only for the good stuff. So they're willing to apply it selectively to a couple of sections of the Charter of Rights and Freedoms, which they think are going to have some good payoffs for their constituency, but will not, absolutely refuse to apply it to the Constitution as a whole. And there's no principled basis for the selection other than the expected outcome. So it's hard really to take that as a principled approach to constitutional inquiry. In Europe, the indifference or the hostility to originalism is more fundamental. In Europe, particularly say in Germany or in adjudication under the European Court of Convention on Human Rights, it's not just that originalism is a dead idea. The whole idea of interpretation is dead. And to understand that, you have to understand something about the architecture of these bills of rights. They proceed in two stages. One is to define whether a right has been limited in some way, and then the second stage is to ask whether that limitation, sometimes called a violation of right, even though at this point it's just a prima facie right, whether that limitation is nevertheless justified. Now, the trend has been towards just inflating the idea of a right wildly, particularly the right to liberty under the German Basic Law. The move there is that almost any conceivable piece of legislation is going to infringe in some way someone's liberty. And so the actual interpretation that needs to be done of the actual constitutional text is minimal. It's just non-existent. So all of the work is done at the second stage, which is done under a proportionality test, which is a stylized way of asking, is this legislation reasonable or not? And I won't go into the details of how that work is done. If you are interested, Grant Huscroft and I have a book coming out with Cambridge University Press in a couple of months called Proportionality and the Rule of Law. I recommend it to all of you. Now, one of the reasons for the popularity of proportionality, I think, is in a lot of these post-World War II constitutions, they're not much of a product of constitutional settlement. They're extremely vague and aspirational. And the point's often overstated, and I think much, like Earl stated earlier, much useful work can be done to uncover the possible settlements that were suggested and rejected. But they leave a lot of room for legislatures and secondarily to courts to continue the act of working out the details of what freedom of religion or freedom of expression actually means in these particular circumstances. So the originalism is ascendant elsewhere is great, but still there are these large jurisdictions where I just don't know that it's ever really going to catch on. Now, on to the second question of the relationship between originalism and judicial restraint. This is more getting to the meat of the paper. When I first met Yvonne yesterday, the conversation naturally turned to my Italian in-laws. And Yvonne suggested, always on task, that this is a fitting metaphor for comparative originalism. Now, on leaving Italy 50 years ago, my wife's family, about half of them diverted to New York and half went to Toronto. The New York bunch became large, loud. They play football and work for the New York Department of Sanitation. And they basically conform to every stereotype of American Italians. The Canadians, on the other hand, maintain the old ways, speaking Italian at home, evading income tax, and claiming pension benefits on behalf of deceased relatives in other countries. Now, Yvonne's point was this. You can take these two groups of people. It's like originalism. You drop them in two different countries, and 50 years later, you've got two different animals. Originalism as judicial restraint is kind of more like the American animal. In Malaysia, you've got originalism as more of a rights-expanding kind of model. I'm not sure I'm convinced that's a useful dichotomy. In the Italian families, for all their differences, they remain united in this. They both still illegally distill grappa in their basements. That's kind of that. They have an essence. Now, my question for you is judicial restraint the grappa of originalism? Now, Yvonne is surely right, it seems to me, to point out that fidelity to the original meaning of a constitutional text does not necessarily entail restraint in the sense of preventing judges from striking down legislation. It all, of course, depends on what the constitutional settlement is that's reflected in the text. But I think there is something universal about restraint in originalism. It entails a fixed semantic meaning of a text. Now, that text might be vague, and the text could conceivably authorize judges to create new rights, to expand the scope of the embryonic rights that they create, or to concretize them, I guess, further specify them. But some things will have to be ruled out. And just how much constraint a Constitution places on a judge obviously depends on the terms of the Constitution. But the restraint is nevertheless a part of originalism. The possibility of rights-expanding interpretations of a constitutional text isn't a challenge, I don't think, to the link between originalism and restraint, provided that the Constitution authorizes the expansion. Because originalism is committed to truth and interpretation, not to narrow definitions of rights. So to give you an example from the Canadian setting, Section 15 of the Charter of Rights provides that every individual is equal before and under the law. It's the anti-discrimination provision, and has the right to equal protection and equal benefit of the law without discrimination. And then there's a long laundry list here. And in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. They debated long and hard about what to put in there. But the court has interpreted that as being just a list of specifications of a general principle, something that they're free to add to. Now, I think that's right. There's nothing about that's expanding rights. It's adding grounds, but it's consistent with originalism, and I think it's textually restrained. Were the Supreme Court of Canada to have instead used this provision, say, to add a right to privacy, that would be unrestrained. Okay? That would be non-originalist. But to be impermissibly rights expanding, the court would need not to simply insist on a broader reading of a clause than the legislature gives, or a broader reading than the court itself gave 10 years earlier. It would need to insist on a broader reading than what was actually fixed at enactment. It's at that point that I don't think we have a practice that's recognizably originalist. An extreme example of this is a gloss taken on the Canadian Persons case by Justice Sharp of the Ontario Court of Appeal. He characterizes the Persons case, which some of you might know, as a precedent that the court can declare that the Constitution allows what the text once expressly prohibited. That's a lack of restraint. Okay, I think we can agree that originalism doesn't allow for this. My difficulty with the Malaysian example that Yvonne uses is that the litigation looks to me just like I would expect it to look if there was a similar Islamic religion clause in the US Constitution and litigated here. Now, admittedly, I'm from out of town, but it looks to me like two sides battling over broader and narrower readings of the same text, but both trying to give effect to a constitutional settlement, trying to hold the other side to what they understand to be the bargain. Readings of the Constitution that expand rights over what the judiciary had previously thought was included, that re-examine what the bargain was, are not necessarily unrestrained or materially different from the originalism we see here. And I'll just conclude by saying that Yvonne was too modest to mention this, but this work may be part of a forthcoming work that's going to be published by Oxford University Press. And for the title of that work, you can ask Jack Balkin, who's been working on it. Okay, so.